So, GDPR and Brexit reforms. We normally only talk about concrete actions on Privacy Kitchen, but the UK government published its response on the consultation on Brexit reforms to UK data protection law in June 2022. There's lots of concerns around it, so with our Privacy Kitchen focus, we'll look at it from the practical perspective, against what you're doing now and what might need to change. Stick with us and you'll be able to judge for yourself how big this might be for you and for your organisation and what to keep an eye on. Hi, I'm Robert Bohr, the founder and CEO of Keepable. We save you time, money and stress on GDPR and all things privacy, giving you a great answer for the board and customers. This video is part of Privacy Kitchen, free video help with GDPR and all things privacy. If you're new here, please do click subscribe and notified to hear about awesome new Privacy Kitchen videos. Grab a coffee and let's go. So on scope, it's easy. There's no change to what is or isn't personal data and no change to territorial scope. If UK GDPR, DPA or PECA apply to you now, that's not going to change. Now on definitions and interpretation, there's a few minor changes in practice. The government's going to push forward with clarifying certain themes in the law itself. Some of this may simply move wording from recitals into definitions or articles. Some might need a bit more. Now we'll have to see the law, but none of this should have a major effect on your practical compliance. First off, research, which was a big area in the consultation paper. There's going to be a new definition for research, but not really new, it's mostly copied from the recitals. There's also going to be clarification on broad consent for research purposes, which will need to be looked at pretty carefully. Linked to research, there's going to be clarification on what constitutes repurposing as opposed to further processing, plus two specific changes. First, repurposing when the legal basis was consent will not be possible subject to limited exceptions. And secondly, some sort of clarification on further processing for an incompatible purpose when based on a law that safeguards important public interest. Another item to look at, see exactly what it says. And on anonymization, the government just wants to clarify when a living individual is identifiable, that the test is relative, and they're going to base it on the wording in the explanatory report to the Council of Europe's Convention 108+, which is the update to Convention 108. The link again is in the notes below. That wording's on page 18. And it includes that data is to be considered anonymous only as long as it's impossible to re-identify the data subject, or if such re-identification would require unreasonable time, effort or resources, taking into consideration available technology at the time of the processing and technological developments. So not really much difference, again, at the moment from what people understand anonymization to be. So what about the core rules of GDPR that we all base our programs on, the GDPR principles and legal bases? Well, there's going to be no change to GDPR's principles, and there'll be no new legal bases in GDPR, which had been suggested. However, how and when you use some of them will slightly change. So let's dive into those quickly now. Right, legitimate interests. There will be a list of activities where the balancing test for legitimate interests is not required. It's going to be much, much shorter, and there'll be a power to update the list. And it generally won't apply when children are involved unless it's, for example, for safeguarding issues. And on the crossover between legitimate interests and consent, particularly on cookies, the government wants to extend the category of cookies where consent's not needed to include traffic cookies and cookies to improve the performance of the website. This generally mirrors what's happening in the negotiations on the draft e-privacy regulation in Europe, so it's not really a surprise. And so you'll be able to use legitimate interests for a broader range of cookies, but still not marketing ones. Now, there's change on the public tasks ground, which is quite useful. In particular, they want to clarify when private entities can rely on the public task ground in Article 6.1e when they're acting on behalf of a public entity in performing its tasks. So that could be helpful, but in limited situations. Now on special categories and artificial intelligence, there'll be a new condition in Schedule 1 to the UK DPA to enable processing sensitive personal data to monitor and correct bias in AI systems. This will not be in the list where you don't need to do a legitimate interest balancing test, which was originally proposed, so you still need to do one. Now, turning to data subject rights, there's two main things to note. A change in the wording for when you can reject or charge for a data subject rights exercise from manifestly unfounded or excessive to vexatious or excessive. So changing manifestly unfounded to vexatious. This is going to need guidance on the actual impact of this change. The government's response suggests they may have quite a broad view of this, so this is going to be one to watch. And Article 22 remains. That's the right to have a human review of automated decisions which have a legal or similarly significant effect on you, the data subject. The government confirmed that the vast majority of respondents opposed the proposal to remove Article 22. Now, while it will remain, there's going to be some clarification on when it applies. This is unlikely to be significant at this point. So while we're on artificial intelligence or AI, we've covered two of the main items: the new condition in Schedule 1 of the UK DPA for using special categories for monitoring and correcting bias in AI systems, and the removal of Article 22 and the right to human review isn't going ahead. There's just going to be some clarification. On transparency, though, it's quite interesting. The government's holding off legislation for now, stating the recently launched Algorithmic Transparency Standard encompasses the categories recommended for transparency reporting during the consultation. So they're going to move this topic forward separately on both of those fronts. And while we're on automated decision-making, the proposals for transparency on automated decision-making in the public sector are not going ahead. Now, accountability is the area with the biggest practical changes, but then again, maybe not. The DCMS consultation paper says in paragraph 158, a strong privacy management program, PMP, is likely in practice to exhibit many of the same features as the current legislation. So, there's no change anyway in these proposals to the security obligations, to use of processors, joint controllers, and more. So what are the issues here? Well, it's DPOs, DPIAs, and Article 30 records, or records of processing activity, or ROPAs. Let's look at what's being moved forward. The one most people are talking about is the removal of DPOs. Even though the government says the majority of responses disagreed with removing DPOs, they're pressing ahead anyway. DPOs will be replaced with a new requirement to appoint a senior responsible individual to oversee data protection. Now, personally, I've always thought the DPO regime had a fatal flaw, the no conflict rule. It's incredibly hard for anyone appropriate in an organization not to be conflicted. And in my view, and I know it's not popular, most external DPOs are pressured to do work that creates a conflict. Now, again, in my view, organizations just really want to get things right and do it quickly. They want an expert to tell them how to get up to speed. And so I've always been in favor of removing the no conflict rule. But this proposal seems, if anything, to make it harder for UK organizations. For one, it's not clear whether all organizations must appoint a senior responsible individual, or only those who under GDPR would need to appoint a DPO, which really is hardly any private entity in reality. And the consultation and the response sets out a lot of obligations for the responsible individual. As examples, they'll develop and implement a PMP, a privacy management program, including policies, procedures, evidence of appropriate reporting to senior management, personal data inventories which describe and explain what data is held, where it's held, why it's being collected, and how sensitive it is. Risk assessment tools to identify, assess, and mitigate privacy risks across the organization, and plans and processes that are operated, monitored, assessed, and reviewed as part of the PMP periodically as necessary. And the government response itself says most of the tasks of a DPO will become the ultimate responsibility of a designated senior individual to oversee as part of the PMP. Even that some organizations might want to keep a DPO anyway as well, which will be separate to the senior individual. So it seems to set out, for me, more express obligations for more organizations possibly than the current DPO requirements and accountability rules in GDPR. Right, DPIAs, risk assessments. We've already seen risk assessments will still be needed in your PMP as appropriate, but then DPIAs aren't always needed under GDPR either. They're only needed when there's a likely high risk to data subjects' rights and freedoms. Now, in their response, the government notes again that the majority of respondents agreed that DPIA requirements are helpful, and they disagreed with the proposal to remove them, but they're going forward with it anyway. The government says under the new PMP, organizations will still be required to identify and manage risks, but will be granted greater flexibility on how to meet these requirements. For example, they'll no longer be required to undertake DPIAs as prescribed in the GDPR, but they will be required to ensure there are risk assessment tools in place to identify, assess, and mitigate data protection risks across the organization. Now, what the government says about the inflexibility of DPIAs is just wrong. There is no set form, so it can be part of a wider assessment as long as it covers the areas in GDPR. But let's not get into that now. Suffice it to say there doesn't seem much of a reduction here. In fact, it arguably seems to increase when risk assessments need to be undertaken, which currently is only when there's a likely high risk. Right, the third main area here is Article 30 records. Now, the term ROPA has become overused. Article 30 of GDPR is in fact called Records of Processing Activities, and sets out tiny summary of details of processing activities that controllers and processors must maintain. But one does need to do that deeper inventory anyway, so you can do your privacy policy, your Article 30 records, and of course remediation to comply in the first place. Now, in the government response, they again note the majority of the respondents disagreed with the proposal to remove the requirement to maintain ROPAs. They also noted half of the respondents disagreed with the statement that Article 30s were duplicative of Articles 13 and 14, that's giving a privacy notice, and in fact they felt that the Article 30s provide the fundamental building block which then helps them to comply with the requirements under Articles 13 and 14 about informing individuals how their data is going to be used, etc. Indeed, in Keepable, we start with the data map and then we build out the Article 30 from there, which is only a summary. Then we can build out all the remediation planning and notifications and gap analysis, etc. It really is the fundamental step. But the government's going forward with removing Article 30 anyway. And they say organisations will need to have personal data inventories as part of the PMP, describing what and where personal data is held, why it's being collected, how sensitive it is, but not required to do so in a way prescribed by the requirements set out in Article 30. So in practice, is there actually going to be any difference? No, I don't really think so. Going on to breaches now and security. Now on security, the big proposal was increasing the level of risk that triggers notification to the UK ICO. That's not going to happen. Everything on breach remains the same. Easy. Right, one of the big ones, transfers. Now the government had also proposed expressly allowing repetitive use of transfer derogations in Article 49 when adequacy or other safeguards like SECs and BCRs weren't available. This is again contrary to the EU position. This proposal is not being pursued. But just as we're getting multiple decisions out of the EEA on the illegality of Google Analytics under EU GDPR, and that there's no risk-based approach to transfers, we've got a great video on this, by the way, the UK government confirms it wants to have a risk-based approach to transfers. Now, whether you agree or not, this is setting the UK on a collision course with Europe. We'll have to wait to see how this ends up in law and how, combined with other changes, it's seen by the various bodies of the EU and what this means for the UK's adequacy decision under EU GDPR. So, turning to PECA, cookies, e-privacy, another big topic in the consultation. We've already seen for cookies, the category where you don't need consent is going to be increased, but that's similar to what's already being discussed in the EU on the new e-privacy regulation, so no real surprise. The government wants to go further and it's keen to reduce cookie tool use as well. So in fact, it even says, and I quote, it intends to legislate to remove the need for websites to display cookie banners to UK residents. Now that's a huge statement, but it appears that most of this cookie area, including relying on browser settings, will not be progressed right now and will be kept under review, particularly as technology changes. Again, the exact wording in the resulting law is going to be really important. A couple of other PECA changes are that the maximum fines will increase to align with GDPR, which most agreed was good, and that the soft opt-in is going to be available for non-commercial organisations such as charities and political parties. Last, let's quickly look at ICO changes. This is an area many commentators, including us, believed, alongside the proposals on transfers, presented the most serious risk to the UK's adequacy decision under EU GDPR. Now, many of the proposals for the ICO were about governance, or either were not controversial, were in line with other regulators, or just codified what happens now in practice. But two are worth keeping an eye on. The ICO will now have a lot more statutory duties and factors to consider in its actions and decisions set out in more detail in the law. That's fine and it's pretty well what they do now, but they also need to take into account a statement of strategic priorities published by the government, albeit at a level below its statutory strategic aims. Now this is even though the government admitted that, and I quote, the majority of respondents disagreed with this proposal. Concerns were raised this measure would pose a risk to the ICO's independence. Well, quite. The second concern is the government's proposal to have the ICO's codes and statutory guidance subject to approval by the Secretary of State, by the government. Again, the government acknowledged, and again I quote, the majority of respondents disagreed with this proposal. Respondents mainly highlighted concerns about the risks to the ICO's independence. Again, quite, and again, this proposal is going ahead as well. Now, as with risk-based transfers, it will be interesting to see how Europe reacts to these limitations on the ICO's independence. So there you go, we'll need to wait for any actual law to see the end results, but now you can take a view on how the proposed changes will affect you and your organisation, and you'll know what to look for as it moves through the process. Please do look at our other videos on Privacy Kitchen, and do visit us at keepable.com to see how we can make your privacy governance, including your new privacy management program, Super intuitive, from data mapping to risk assessment, breach management, processes, transfers, and more. Do let us know your thoughts on these reforms on LinkedIn and Twitter using #PrivacyKitchen, and do use #PrivacyKitchen to let us know the other topics and questions you want covered. We hope you enjoyed this video. Stay well in the meantime, and we'll see you soon in Privacy Kitchen.